Christopher Clinton is called 19-328-15. Sir, you are prominently known to this court and others to having the longest caption of names in an indictment in history, which have all been crossed out.
Right. They've been abandoned. Turns out it was not correct.
I've never seen that in my lifetime. Such a cacophony of names, which has dwindled down, strangely enough, to the first name that was on there, Christopher Clinton. Is that
yes, sir.
Is that your final answer?
Yes, sir.
Okay. Okay. Now, this is an issue where I think this is the avenue that such a thing is accomplished. There may be other ways, but this is just as good a way as any, is applying for and being granted a writ of habeas corpus, which requests exemption from registration. Now, as the state, there's your response, which is
it's captioned incorrectly, Judge.
I haven't read yours.
I think you should strike it since it's captioned incorrectly.
Well, the captions, as you know, are like horseshoes.
Yes, Judge.
Close
sufficient.
Yes.
Horseshoes and hand grenades.
So obviously 9 wasn't. Does this have an end to it, or
Judge, our appellate department drafted that, so probably not.
I'm sorry I didn't read this before.
It's okay.
Right.
I can kind of give you an idea of what the issue is that you're looking at if you would like.
I'm getting through it. I'm more than halfway through.
Yes, sir.
It's good enough for this court.
I stand by every word, Judge.
All right. And it repeats itself several times what the theme is. And I guess the indictment here in 19-328-15 in substance states or alleges that the defendant while being a person required to register with the local law enforcement authority in the municipality where the defendant resided or intended to reside for more than 7 days, namely Beaumont, Texas, because of a reportable conviction for sexual misconduct, intentionally and knowingly failed to register with the local law enforcement authority is in that municipality, which here constitutes a third-degree felony in this indictment. All right. I think I see where we are. Go ahead. What do you have to add?
I think the state's response addresses a challenge that I've had with this case from the very beginning, which is that it's my position or our position that Mr. Clinton is entitled to some level of relief and certainly not to a felony conviction for failing to register. However, the avenue or the vehicle for obtaining that relief appears to me to be unclear. And the reason for that, and that's why we're kind of letting you be the judge here and coming to you and handing you our problems. But A 62.301
Right.
can't be the right vehicle because it doesn't apply to Arkansas courts, and the court that would make the decision in 62.301 would be the home court. And so in a normal case, if his alleged conviction was out of this court, we'd come back to this court and you could grant relief under 62.301. So as they point out, that may not be the right vehicle because we don't know what the court is. And again, Texas law doesn't apply to Arkansas courts. And so that's why we chose to go with this vehicle of a writ of habeas corpus, because it's our position that there are no misdemeanors that require registration, no misdemeanor convictions under Texas law that require registration. This is a misdemeanor conviction out of Arkansas. The law at the time in Arkansas law, the offense itself, if we take the state's discovery as authentic, which I always just assumed it was, the law in Arkansas, the allegations in Arkansas would not have been a crime, or at the very least, they would have been an obviously affirmative defense crime that no one would have ever pled guilty to. That avenue was not available to Mr. Clinton under Arkansas law, but it would be under Texas. And so what essentially is happening here, and the reason we believe he is unlawfully under Texas law restrained of his liberty, is that he is being required to register and also is subject to an indictment for failing to register for something for which he would not be required to register under Texas law. And even if he were required to register under Texas law, assume those facts were all true for a moment. If this were a Texas case and he had been convicted under that law, 62.301 would also provide a separate avenue for relief that is not really available to him because, again, the court that we're talking about is in Arkansas, not Texas. And so it's our position he is entitled to relief, both from registration and from this allegation, from this indictment. But again, we're not fully confident about the vehicle that we're using, but it is, after looking at all the options, it was the most logical one that we could get into and drive to the court.
$62,301 is on page 587, Judge. Yeah, did you before? See what it says in the phone? Or do you have it?
It's whatever it says in my written. I did it at the time. I don't have it from here.
All right. What about in this response, the state cites Crabtree, which was also stated here in the Bar Association's product about handling matters that are from other jurisdictions, and when a defendant's duty to register arises from a conviction for a non-Texas offense, That's what we have here. It is an element of failure to register as a sex offender that DPS determined that the non-Texas offense contained elements substantially similar to a Texas registerable offense.
This is in our discovery.
And-
This is the determination.
What is the, what do you contend is the substantially similar offense here in Texas, if any?
I'm not sure what you're asking, Judge.
In Crabtree that y'all have cited as authority.
That's set substantially similar to a Texas registered
Yellow
offense.
appellate determined that the non-Texas offense, which is what we're talking about here, contained elements substantially similar to a Texas registerable offense. So
And so DPS has made that determination right here.
what is the offense for which he was convicted in Arkansas, you contend is under the case decision has elements substantially similar.
It
Don't
was,
just show me, tell me, what is it?
but Judge,
what is the
what
Texas?
that case right there says is not that we have to show or tell. It's that the DPS has made that determination.
What is it? What is the case? What is
DPS
the law?
saying sexual assault.
DPS is saying
Just asking
it
you,
is
what is
sexual assault of a child 22.011A2. And that is any offense for sexual misconduct under the Arkansas Code annotated before 2002. DPS has made that determination right here.
What are the elements of that? Simply just, this is just simple question. The Arkansas conviction, what are the elements of that offense and how are they similar to what the Texas offense is?
They are virtually the same. I think the
No,
issue
compare them. Tell me what they're. I want to know
that they
Like I'm in
that
first
they
grade.
involve having either genital contact or penetration with a child under a certain age. In Texas, 17. I don't know what it was in Arkansas, but I believe it was probably either 15 or 18.
Nonetheless, I don't know.
Right.
But
And the child in this instance was, I think we basically agree that the child was 15.
okay.
I think their issue would be that there was.
Let me ask. Let me just get to the bottom, and then I'll sway. Y'all give me some closing statements because I think I get a grasp on this. The similar act, the similar statute that you're saying from what he was convicted of in Arkansas compares to the Texas statute is what statute and what degree crime is it?
And it is sexual assault of a child.
Okay.
Section
Second degree.
22.
Is that second degree felony?
Yes, sir. 22.011A2.
Okay. Which carries with it up to 20 years in prison.
Yes, sir.
That Arkansas statute that is similar. What was the punishment range for that?
Up to a year in jail. And
Wow.
Judge, the Arkansas statute had some weird requirements, but it reads almost like the 62.301 requirements, which is that it's someone older than 15. It requires intercourse. It's not just digital penetration or oral penetration. It actually uses the word intercourse between a 15-year-old and a person that is less than 3 years older. So in other words, 15 to 18. And so they people within 3 years of each other is specifically what it's talking about. From 15, as long as the complainant is a minimum of 15, and that makes it, that would be a misdemeanor. And so
it doesn't have to be word for word exactly.
for sure,
And
that
it doesn't have to merit. That's not the test.
actually, I'm answering the court's question.
And Texas, there are many reasons I enjoy and prefer and glad I was born in Texas and stayed in Texas. I'm in that sentence and go
Yes.
to another thought, but this, for example, is a reason. Is like an exhibit. The test is an offense which contains elements substantially similar. And it doesn't have to be exact, it's substantially similar. And the state of Texas, their presentation the way I read this and the way I understand the arguments, that they contend these fit that requirement under law that Texas has a crime of second degree felony with elements substantially similar to the what would it be, a class A misdemeanor, I guess, in Texas, punishment range, similar punishment range. And the fact that you have 3 levels difference of punishment levels of seriousness that Texas considers for substantially similar conduct for what Arkansas considered was worthy of punishing under law. That, other than kind of a surprise or bizarre look at things of how 2 states can look at similar types of conduct when we're talking about something that is universally condemned, and that is sexually harming a child.
But Judge, may I address?
But that's, to me, not as important. It's what Arkansas wants to call levels of crime versus Texas. This the point is that the indictment that was handed up, I don't see why it was not handed, where it can be shown it was handed up in bad faith or without probable cause based upon what we follow in Texas law and what our statutes say are the tests. And the defendant can, I guess, go anywhere he wants. It's a free country, but the rules in one state may be applied in a different way than rules in another state. And Texas, the state of Texas has always, and I think all states should, strictly enforce the rules and hold people accountable to following the rules when they may fit within sex offender registration requirements. And I think there's a way that you could have maybe tested this without being arrested. How you wanted to move about in your life was your business, but you've gotten Texas authorities' attention. And I don't know if you intended to make this a test case or not, but this court is not going to grant the relief you were asking because of what I deem, as I read this and listen to the arguments and read the documents here. This has, even if I agreed or not, the way the law works in the steps that are taken right now, I'm convinced that the state had authority to review this case, and if deemed appropriate, to move forward with an indictment. And the law allows that, and you probably would have been better served in your personal situation by complying, by registering with sex offender registration requirements in Texas in an abundance of caution, but you didn't. And at what this court has, and what I've looked at, even though this is the first time I've ever seen the comparison of a second degree felony to a class A misdemeanor of substantially similar elements of an offense between 2 jurisdictions, they can differ. Even though I may strongly believe that the Texas version of those elements of conduct are more appropriate to be enforced, but the fact that Arkansas may deem differently. And didn't you say that they had changed the law?
They did, Judge.
Is it more serious now?
In 2002, I
It
believe.
is, but Judge, I'm sorry to interrupt, but I would point out to the court that the elements are the way that they are not substantially similar is that Arkansas capped the age of the person that this would apply to in terms of a defendant. And the other way is that Texas law specifically.
Wait, hold on. Quickly, that they cap the age where that this would, what would you mean?
Well,
That who would be subject to prosecution?
correct.
Okay, as at what now?
In other words, a very, very narrow window of people as both complainant and defendant would apply to this misdemeanor sexual misconduct. In other words, you can't be a 35-year-old and have a sex with a 15-year-old and get this offense. That's not what we're talking about. We're talking about offenses that solely would fall, only offenses that would fall under our Romeo and Juliet defense, which would be an absolute defense. So the argument is, Judge, I understand you're suggesting that maybe Texas was being harsher, but in fact, Texas is being lighter on this.
No, so your argument is adults are free to commit that otherwise commit that crime of sexual misconduct, but people within 3 years of the age would be subject to the prosecution, but adults are free to harm the children.
No, Judge.
Well, that's what you just said.
No, it's not, Judge. What I said is there's a whole nother felony
adults. You're saying adults are not subject
to this,
to that, but the children would be. So if the adults did the same thing that children within 3 years of the age of the victim, then the adults have a get out of jail free card for sexual misconduct.
No, a much higher felony charge.
Well,
that's what makes it different, Judge.
If it were, then it would fit something here, right?
It does, Judge, and that's why it's not even an offense here. People within 3 years, as long as the intercourse is consensual, have an absolute defense under the Romeo and Juliet defense. They have an absolute defense, so they would not ever be prosecuted under this set of facts.
I don't think that defense is absolute, but.
Well, okay. But that avenue wasn't available for this sexual misconduct misdemeanor. And so the reason it's a misdemeanor is they obviously think that, high schoolers that are having sex, that's going to be against the law there, but it's going to be a misdemeanor. Whereas here, when that happens, we have the Romeo and Juliet defense that as long as it's consensual, it's not sexual assault. And so the only element you have to prove to get out of the sexual assault is for the complainant to say it's consensual, which is what happened in this case.
The Department of Public Safety has made the determination that these are similar.
What about that?
And my argument would be, Judge, that
well, it's not the test, it's substantially similar. That's what they said.
Right. Yes, and that's the determination they've made.
I think they're wrong, Judge. I mean, some bureaucrat
so
that may or may not be a lawyer is coming up with that.
I can't imagine a defense attorney saying such a thing.
And Judge, here's where I'll tell you this: what they're asking for is
I argued as hard as I could for my client. But what about that? What do you say is wrong about their review and determination?
What I would say is wrong is, Judge, it just doesn't help your client. Well, no, I think if someone that actually spent time with the two statutes, really spent time with them, could not reach that conclusion because
they're just wrong.
Under Texas law, if it's consensual, which again, to be the sexual misconduct misdemeanor in Arkansas, it has to be consensual. Under Texas law, that's not an element.
Do you have that documentation of their review and determination? Did they make a proclamation or something?
That's what I presented to you just a while ago.
Is that part of this packet right there?
It's just a chart that DPS produced.
Published May 24, 2017.
Oh, okay. They didn't take a review particularly of this particular case. Or did they?
No, not this particular statute. And you'll see at the very bottom of that chart right there, that's their determination as to this
Oh, okay.
specific statute.
Okay, they've already done it.
Yes, sir.
Okay.
And see,
Well, I
that's
don't-
what's problematic, Judge, is that
This-
is any order you issue would not be
Can you-
enforceable in any other
can you
county.
Label this as
I
your
will.
exhibit, and then we'll make it a part of the record in this hearing. You want to call it states one, I guess?
Yes.
And stage one is moved into evidence in this hearing without objection.
But we have no objection.
It's
We don't
admitted.
know what.
And in summary, state's exhibit one is what the state contends is its basis, its strong basis to support the fact that this county can indict the defendant for his failure to comply with sex offender registration requirements. This state's exhibit one. State's exhibit one is admitted. Defense, your summary is that it's just plain wrong because, hold on, the court is looking at on page 2 of 6. And I guess you only did 1 and 2 because 3, 4, 5, and 6 are not
Those
really
are the only
relevant
applicable.
to
Yes,
this
sir.
issue. But at the bottom of 2, it says this is called a determination under Article 62.003 Code of Criminal Procedure. Offenses under the laws of Arkansas, Texas Department of Public Safety produced this. And this is their review. That to the sentence that states that the listing of Arkansas statutes that are listed in page 2 are deemed, it says determinations under Article 62.003 Code of Criminal Procedure, offenses again under the laws of Arkansas. For purposes of Chapter 62 of the Code of Criminal Procedure, the Texas Department of Public Safety, the department is responsible for determining whether an offense under the laws of another state contain elements that are substantially similar to the elements of an offense under the laws of this state. That's what they proclaim in this publication.
Right, Judge. And
Hold on.
62.03 is that statute
Let me
titled Determination regarding substantially similar elements.
Okay, it's inherent, it's here under this publication. And by the way, this publication is dated May 24th, 2017. There is not another update to this as far as you were aware?
No, sir. No, sir.
It goes on to state at the bottom of page 1, this is not an exhaustive list of Arkansas offenses that require registration. If an offense is not on this list and you believe the offense may require registration, please contact the Sex Offender Registration Bureau for a determination. At the bottom of page 2, Arkansas Code annotated section 5-14-107, sexual misconduct. And that is the crime that the defendant was convicted of in
1990.
Yes, sir.
1999.
Yes, sir.
Okay, and it says offense date before 2002 is also included here. And the Texas offense that the DPS deems is a crime which has substantially similar elements to the offense of Texas. The crime in Arkansas is that the defendant has been indicted for is listed here at the bottom of page 2, section, which is section 5-14-107, sexual misconduct. All parties agree that was the crime the defendant was convicted of in 1999. And then the Texas offense, according to the DPS publication, that has substantially similar, which has a substantially similar set of elements to it, is referred to as section 22.011, subpart A, subpart 2, Texas Penal Code, sexual assault of a child. And even though that's not alleged verbatim in this indictment, that's what the state is contending is the appropriate statute, which is a second-degree felony in the state of Texas.
Yes, sir.
All right. So this is made a part of the record, the state's exhibit 1 for all purposes in this hearing. Anything else?
I mean, we just think that's inapplicable. We think that determination is incorrect. In numerous ways, the elements are not the same.
It doesn't have to be.
It has to be substantially similar.
Okay.
And they are not similar really at all.
And in all due respect, you agree, though, the Texas Department of Public Safety in their publication disagrees.
I think that someone at
No, is that
DPS
right?
disagrees. Yes.
Okay, all right. And here this is also state that for purposes of Chapter 62 of the Code of Criminal Procedure, it is the Texas Department of Public Safety who is claiming responsibility under the law for determining whether an offense under the laws of the state contain elements that are substantially similar to the elements of an offense under the laws of this state and another state.
Which is what that Crawford case says, Judge.
Which is
Crabtree.
supported and
Crabtree.
Crabtree. No, it's Crabtree.
Yes, sir.
Let's cite for the record.
Crabtree v. State, 389 Southwest 3rd, 820, Texas Criminal Court of Appeals, 2012.
State offenses. Yeah. 389 Southwest 3rd, 820 at 825. And that is a Texas Court of Criminal Appeals decision in 2012, which interprets Articles 62.001, subpart 5, subpart H, and Article 62.003.
And Judge, we would object to the application of that statute as well for this reason, because it's a unconstitutional usurpation of judicial power. Essentially, the legislature is handing at some bureaucrat the power that ought to be yours, the judge who is also a licensed lawyer and counselor in the state of Texas, to determine whether the statute is substantially similar, rather than some unknown, unfaced bureaucrat that we don't know who wrote this chart. And so it deprives my client of his due process, because essentially what the legislature has done is taken the power from you and said, and really from themselves, and said, we're going to hand it to the executive branch and let some guy at the executive branch make a determination that this misdemeanor is going to become a felony or whatever.
But okay, you object to that, but that's what the legislation states.
I don't disagree with
Okay.
what it reads.
Well, I've taken an oath to follow the law. And that's until that changes, and there is a method of a review that could change that, but the court is going to deny you relief and in all due respect, based upon these reasons that the court has placed into the record. I think I've touched base with all of them.
Yes, sir.
Anything else to add?
No, sir.
Not this-
Okay. What do you want to do now? Well, no, I know. What, I'm just talking about, what do you want to do in placing the next
Could
event?
we get 6 weeks for an announcement?
I'll give you 8. Okay.
Hey, that's
And
great. Thank
See
you.
what you want to do. You may want to do some sort of interlocutory relief here.
We may.
Okay.
Thank you, Judge.
That is all. Thank you. We're in recess shortly, so we can get the jury together and pick up this murder trial. And we are in.